All right. First of all, I want to thank all of you for being here tonight. We really appreciate the support. Professor Richard Levy is a nationally and internationally known teacher and scholar in the field of American public law, including constitutional law, administrative law, and legislation. He joined KU Law faculty in 1985, having received his law degree with honors from the University of Chicago Law School. Before joining the faculty, he served as a clerk for Judge Richard Posner of the U.S. Court of Appeals for the Seventh Circuit. Professor Levy is a prolific scholar with an extensive publication record in leading journals on a wide array of topics, including pioneering work applying collective action theory to federalism and leading articles on judicial review of administrative agencies. He was named the inaugural J.B. Smith Distinguished Professor of Constitutional Law in 2007, which also, what an amazingly great title. I'm jealous of it. So just a couple of bits of housekeeping. Feel free to submit any of your questions along the way. We have chat turned off just because we find it's a little bit distracting while the program's going on, but you can chat to me if you have questions. I'll moderate, get them asked, and at the end we'll also have some time for questions. You can ask those out loud or you can submit them to me if you feel shy. Either way is fine. If you need to adjust your view in your Zoom, it's in the upper right-hand corner. It says view. It's fairly self-explanatory. Feel free to play along with it. And with that, we'll get started.
Okay, thank you, Ashley, both for the introduction and for inviting me to speak to the group today. And I do appreciate everyone coming out. I suspect there might be more fun things you could do on a Thursday evening, but there's nothing unfun about constitutional law or freedom of speech, at least from my perspective. To try to give you just a game plan, what I plan to do is to talk first just generally about freedom of speech and the doctrine that the United States Supreme Court has developed concerning when and under what circumstances the government might be able to restrict speech. And then we'll talk about a couple of recent events and the free speech issues they raise, particularly questions of incitement and free speech and social media and free speech. So I do welcome questions, and I'm particularly hopeful that maybe when I'm done, we can engage in a more open and free-flowing conversation rather than have everything come by way of chat. So with that out of the way, let's talk about freedom of speech. So the protection of freedom of speech is found in the First Amendment to the United States Constitution. That amendment actually protects a number of rights. It provides in exact language that Congress shall make no law respecting an establishment of religion. That's called the Establishment Clause. Prohibiting the free exercise of religion. That's the Free Exercise Clause. Abridging freedom of speech or the press, or the right of the people to peaceably to assemble and to petition the government for a redress of grievances. So those 6 distinct protections in the First Amendment all relate to essentially expression by individuals, and the First Amendment provides broad protection for expression in a variety of forms. Our focus is going to be on freedom of speech. Now, one thing that people may not understand is that although the text of the First Amendment says Congress shall make no law, the limitations in the First Amendment apply to all of government. So all of the federal government, not just Congress, and all the states and subdivisions of the states as well. So any government action that restricts speech would be subject to the First Amendment. Now, when we talk about freedom of speech, we really include all forms of expression. That would be verbal elocution, like I'm doing right now, written word, singing, and also various kinds of expressive conduct, like demonstrations, for example, are all protected forms of speech. Now, also notwithstanding the language of the First Amendment, freedom of speech is not absolute. So although it says Congress shall make no law abridging freedom of the speech, many of laws do have an impact on speech and are nonetheless constitutionally valid. So you probably heard the famous phrase that a person cannot shout fire in a crowded theater. Technically, it's falsely shouting fire in a crowded theater that you can't do. If there's really a fire, it's okay. You can shout fire and you're not really violating the law to do that. The reason why constitutional law is very complicated is often because the United States Supreme Court hands down a whole bunch of decisions, and they're hard to put together and figure out what the rules are. And free speech is a great example of that. So I'm going to try to explain the basic rules for you so that you have a better understanding of what the law is in this area. I'm going to start with the basic question: why do we protect freedom of speech and relatedly freedom of press? So it's the very first set of rights that are listed in the Constitution in the First Amendment, and that highlights how important it is. And there's three basic rationales or justifications that are typically advanced for protecting freedom of speech. One idea is that freedom of speech is critical to the functioning of a democracy. We need freedom of speech because it's essential to our informed political participation as voters, as candidates, as people holding government accountable. And so freedom of speech also acts as a check on the government. The ability to speak about what the government is doing allows voters to act and hold the government accountable. And on the flip side of that, the framers of the Constitution understood that tyrannical systems often thrived on the suppression of dissent and dissenting views. So speech is necessary for a functioning democracy. A second idea is based on what's called the marketplace of ideas. So in this view, we protect freedom of speech because that's the best way to get at the truth. And the idea would be that in the give and take and rough and tumble of speech and argument, truth will out, and the validity of an idea will be tested by its ability to gain acceptance. I think these days we may be questioning the validity of that assumption, given that false speech has a life of its own, particularly in the area of social media. But there's also important lessons historically from periods when the government tried to tell everybody what to believe and what was true. And it turns out that that sort of prescribed orthodoxy was false. And it was difficult to make progress because people were not allowed to question the truth of things like the Earth being the center of the solar system would be a classic example of a prescribed orthodoxy that proved to be wrong. And in the marketplace of ideas, if we think speech is false, the remedy for that is counter speech, that is to disprove the false speech. A third and final reason why we would protect speech is because we value speech as a mode of expression. So if in the first two, speech and democracy and the marketplace of ideas, we protect speech in order to accomplish some larger goal. Speech to protect democracy, speech to determine truth. The last idea is speech is a value in and of itself because it's a critical mode of individual expression for people. So that has a kind of intrinsic value worthy of protection on its own. Speech is what gives us art, it gives us poetry, it gives us literature. All those things are valuable modes of self-expression. So in this context, speech is the end and not just a means to an end. So these ideas all show up in the way that the Supreme Court and lower courts think about speech and protecting freedom of speech under the First Amendment. Building on these ideas, let's talk about what I'll call free speech doctrine and the various rules that apply when we're dealing with freedom of speech. So one important rule that a lot of people don't understand is that free speech only limits the government. So this is sometimes called the state action requirement. So the only people that could ever violate your First Amendment rights are government officials, government agencies, and the like. It does not limit the action of private persons or private individuals. So for example, if your local newspaper shuts you out of the comments that come below, or Facebook shuts you down, they can't violate your First Amendment rights because they're not the government. They're only private companies, and the First Amendment does not apply to them. So everything that follows is talking about limitations on what the government can do. It does not apply to private actors. So the first and most basic rule of freedom of speech doctrine is that laws that target speech based on its content-based laws, are especially dangerous from a First Amendment perspective. So they're especially problematic or dangerous because they're more likely to reflect an abuse of power. So the government is shutting down a particular idea or viewpoint. That's more likely to be an abuse of power than something that's more neutral. Also, if you like the marketplace of ideas, if you take certain ideas out of the marketplace, you're going to distort it. It's not going to function effectively as a vehicle for determining truth. So when a law targets speech because of the message in the speech, that's a content-based law, and that's going to be especially likely to be invalid. And the test that the court has articulated for content-based laws that limit speech is called strict scrutiny. A law that restricts speech because of its content has to serve compelling governmental interest, not just ordinary interests, but interests that are compelling, especially weighty. And the restriction has to be very narrowly tailored. It has to be absolutely necessary to accomplish that compelling governmental interest. It can't restrict any more speech than is necessary to achieve its objective. And it's very hard for laws to pass strict scrutiny. It does sometimes, though, happen. There's a couple of examples that you might be interested in, recent cases. So in a case called Holder versus Humanitarian Law Project, the Supreme Court said that a law prohibiting giving aid and comfort to terrorist organizations was valid even as applied to speech, teaching terrorist organizations, and the like. And in another case, maybe relevant to recent events a little bit, in Burson versus Freeman, the Supreme Court said the state could create an area around polling places that prohibited electioneering. So you couldn't have signs or efforts to persuade people to vote for a candidate right there at the polls. And both of those laws survived strict scrutiny. But they're really the exceptions that prove the rule. Most of the time, content-based laws are going to be invalid under strict scrutiny. Now, in addition to that, however, there are some categories of speech that are unprotected and can be prohibited or prescribed, as the court says. These categories might be familiar to you from some of the things that you've heard. So these are categories of speech that can be restricted because of their content. Examples include incitement, threats, what are called fighting words, libel, and of course, the most famous example would be obscenity, which can be prohibited because of its content. Now, these are narrowly defined specific categories of speech that can be regulated, and the court has explained that these categories can be regulated because this kind of speech is really not an expression of ideas. It lacks any value in terms of the purposes of the First Amendment. And also because these types of speech cause direct, immediate, and concrete harms. And so it's not enough to wait for counter speech. You can't fix the harm caused by this type of speech just by disagreeing or disproving it. So although most kinds of content-based regulation are going to be invalid, laws that target unprotected speech like incitement, threats, fighting words, libel, obscenity do not violate the First Amendment. Now there's, I'm not going to get into the details, but there's a lot of disagreement right now within the Supreme Court about exactly how this doctrine works, what the categories are, what the limits of the categories are. I'm not going to get into that detail now, although I'm happy to talk about it if people want to know. So in contrast to content-based laws, other laws may restrict speech that don't depend on the content of the speech. Those kinds of laws are called content-neutral laws, and they are less threatening to the purposes of the First Amendment. There's two primary categories of content-neutral laws. One kind of category is called time, place, and manner restrictions. An example of a time, place, and manner restriction would be a law that limited the volume of noise after 10 o'clock at night in public. So it doesn't matter what you say under those circumstances. It's independent of content. It's just how loud, when, that sort of thing that's involved. So that kind of restriction does limit speech, but not as dangerously as a content-based restriction. In addition, there are laws that might regulate conduct that are focused on conduct, but nonetheless could be applied to conduct that is meant to be expressive. So just to give you an extreme example, if I decided I wanted to assassinate a political leader in order to make a political statement, I'm expressing an idea. The government could still punish me for an assassination, not because of what I'm saying, but because of what I did. And as long as they're focused on the conduct and not the message behind the conduct, that kind of regulation is also permissible. These kinds of laws are less dangerous, and they're generally subject to what's called intermediate scrutiny, which is easier to satisfy. But if a law is too broad, it may still violate intermediate scrutiny. And also, neutrality may be in doubt. So some of you may have heard that a law prohibiting burning the American flag is a violation of freedom of speech. And that's because the laws in question don't prohibit all flag burning. They only prohibit flag burning if the purpose is to express a message of disapproval of the United States. If you're burning a flag as a respectful means of retiring the flag from use, that was permissible under the law. So the law, although it focuses on conduct, flag burning, it's really targeting a particular message, and the court treated that as a content-based restriction. So I'm almost done with the doctrine. One more slide on doctrine. And that is addressing a couple of additional areas or ideas that are hard to sort through. So there are some other special rules regarding regulations of speech. So one rule prohibits or virtually prohibits all forms of what are called prior restraints. So a prior restraint prevents speech before it happens. An example would be licensing of the press or injunctions that prohibit people from speaking. And these are seen as especially dangerous and almost per se invalid. So almost no kind of licensing or injunction regarding speech can survive the First Amendment. There are also special rules about laws that might be too vague or too broad. These kinds of laws would be laws that target speech that might be limited, like obscenity, but either they are so vague that nobody knows what they mean, they don't have fair notice, or they're too broad so that they not only apply to unprotected speech, they also apply to protected speech. So these requirements sort of impose special duties to draft statutes very carefully to ensure that if you're regulating speech, even if you may regulate that kind of speech, you have to do so with very clear laws that don't sweep any more broadly than necessary. And a final sort of issue that shows up a fair amount is speech on government property. So when you speak on your own property, your rights are very broad. What about speaking on government property? Well, there are traditional types of government property that are used for speech, like the sidewalks, the streets, the parks. And the Supreme Court has indicated that your right to speak in these public forums is protected at the highest level. And the government generally can't regulate speech in public forums except in accordance with the rules that we've already talked about. Other kinds of government property may be public forums, but only for specific purposes. So for example, at KU where I teach, all student groups are allowed to use classrooms that are for club meetings and things like that. So those rooms are public forums, but only for a limited purpose. They don't have to be open to all comers, but they do have to be open to students on equal terms. And other types of government property are not public forums at all. So you have no right to speak there at all. So just to give you an example, you would have no right to enter the Capitol and go on to the Senate floor in order to state a message. That would not be a public forum that people could use for purposes of speech. On the other hand, the mall in front of the Capitol would be a classic public forum where speech would be protected.
We have a question.
Okay.
Are content neutral laws what the government uses to limit protest?
To some extent, yes. So if we're talking about a protest that may involve, let's say, a march or a large number of people going into the streets or parks, that may interfere with traffic and other uses of the sidewalks and streets. And the government can neutrally regulate those in order to prevent blocking traffic and things like that. So that kind of content neutral regulation is permitted. Other kinds of protests are limited less because of how that sort of they neutrally interfere with other activities and more because they may threaten to become violent or provoke hostility between onlookers. And there, that would be a content neutral kind of restriction because it depends on the message. And that's where we get close to the incitement problem. So I hope I answered the question in an appropriate way. Okay, so let's talk about incitement and insurrection.
I have a
Yeah.
clarifying question. How clearly defined is the neutrality of that regulation?
It must be very neutral. So it has to, it can't even allow discretion. So if let's say you had to go to an official in the parks department in order to get a permit to have a protest in a public area, the official cannot have any discretion to deny the permit based on anything other than timing. They couldn't have any discretion to decide, oh, I like this one, so I'll grant the permit. I don't like that one, so I'll deny it. If there's any kind of discretion there, then the permitting system would be invalid. It's only if it's neutral that it would be valid.
Okay. And I think we had another one. It's, what do you think about Bill 230?
Bill 230? Okay, so that relates to, if I understand the reference, that's social media platforms, and that bill or that statute protects social media from consequences for the things that are posted. Is that what the question relates to?
I'm gonna call the person out. Truman, is that the question you had?
No, it yeah, that was the question I had, but it protects also like the people from being like, it had something to do with their like First Amendment rights being violated because of the certain political parties they were in as well. And there's nothing been like anything on social media before, so I was just wondering about that.
Well, so right now, the way the social, and we're getting a little bit ahead, but that's fine. Right now, the way social media regulation is set up, it treats the social media provider kind of like the phone company. So they provide the mechanism through which communication takes place, but they have no responsibility for what's being said. And that protection was provided to them by statute 10, 15 years ago. I don't know the full details of all of that. And it's part of what's allowed them to flourish, because otherwise they'd have to worry that if somebody posted something that violated a copyright or that was obscene or that in any other way, they might be liable for it. And that's why that statutory protection is there. But I think right now, there's some concern that they may have too much control and that there's some effort to rein that in, but I haven't followed the details of social media regulation. Is that responsive, Truman? Okay. So we got a little bit ahead of ourselves here because I am going to talk a little more about social media, but let's talk about incitement and insurrection. So some of you may know there was stuff that went on January 6th. I'm going to assume that people are vaguely familiar with that. And one of the questions that's sort of been lurking in the background, it was debated in connection with the impeachment proceeding, is whether there was incitement of the crowd in that context, or whether the speech by former President Trump and others was protected political speech that didn't cross the line into incitement. So incitement is a well-established category of speech that can be regulated and that's not protected. And in fact, the very earliest free speech cases dealt with this problem of when the government could go after people for inciting violence, revolution, other kinds of unlawful conduct. In a famous decision from the 19 teens, Justice Oliver Wendell Holmes said, well, the government could regulate speech when it represents a clear and present danger of inciting unlawful conduct. So you may have heard that phrase as well, the clear and present danger test. The modern test, which builds on that test, comes from a case called Brandenburg And under the Brandenburg test, incitement is not protected as speech if it's directed to incitement of imminent unlawful conduct and likely to incite imminent unlawful conduct. So under this test, there's really three things that you have to worry about. So the first word, directed, implies intent. So the speaker has to intend to incite. Secondly, what is incited is imminent unlawful conduct. So imminent means it's going to happen right now, not some indefinite time in the future. And so you could try your best to incite unlawful conduct 20 years from now. You're not going to succeed. You're not going to violate the Brandenburg test. And then finally, it has to be likely to incite imminent unlawful conduct. So you have to be able to predict the outcome is highly likely. So intent, imminence, and likelihood, those are the elements of incitement. So we might ask that question then, in the case of the Capitol insurrection, did former President Trump incite imminent unlawful conduct that was likely to occur? First of all, I don't think, although we don't have a clear answer, it doesn't have to be explicit. So I don't think it matters whether President Trump said, go engage in violence, insurrection against the Capitol. That's not a requirement of the test. So I think the main issue would likely be intent, whether President Trump's speech was intended to incite imminent unlawful conduct. I think it was pretty clear in context that unlawful conduct was imminent and that President Trump's speech was likely to cause it. And most of the debate is about whether he was intending to accomplish that objective. I'll leave you all to make that judgment on your own. I won't purport to know what was in his mind. Now, one point that we should make clear, however, is that it's not even clear that the Brandenburg test should apply, because what we're dealing with is impeachment, not a criminal prosecution. And so I personally don't think that Brandenburg was really the issue in that case. In any event, the president was speaking as the president and not an ordinary private person. And so ordinary free speech rules don't apply when a person is acting as a government official. Turns out you don't have freedom to say whatever you want as a government official in the course of the performance of your duties. Okay, so that's what I had to say about incitement and insurrection. Maybe I'll pause now and see if anybody has any questions about this issue.
I haven't had any come through, but if anyone has a question, feel free to unmute yourself and ask, or you can message me.
I'm trying to incite an imminent lawful question.
A question did come through.
Success.
Is speech by the president protected under the First Amendment if the First Amendment is designed to protect the people from the government? The president is arguably the person who is most associated with government authority.
Okay, so there are rules about speaking in your capacity as a government actor. So I run into that, for example, as a professor of constitutional law. When I am speaking in class as a teacher, I don't have a right to say whatever I want, because I am fulfilling a role as an employee of the government, and they have a right to say the parameters of what I'm allowed to speak. Now, there are other principles that help me, academic freedom and the like. So I have a lot of flexibility, but I don't have freedom of speech in the broadest sense when I'm in the classroom. Likewise, a member of the government, state government, federal government, also is constrained in their rights because when they are acting as a government official. Now, the hard part with President Trump and the president more generally is that it's hard to tell when they're being official and when they're being private. And it's hard to separate the person from the office. It's pretty clear that when a president is campaigning for re-election, the president is speaking as a private person and has full First Amendment rights. On the other hand, there are laws that limit what a president can do as president, that at least nominally say the president can't sit in the Oval Office behind the presidential seal and give an official speech that is essentially a campaign speech. Now those rules are violated in more commonly than we would like to think. So it's hard to separate out what President Trump, what President Obama, what President Biden, what President Reagan or anybody else says from their campaign, especially these days since the campaigns never seem to stop. Now, there's also an issue with the president because I don't think there's any person certainly in the United States, whose words carry more weight than the president's, that have more capacity to incite or to cause injury. And so I think that in assessing whether or not the president's speech is permissible, and this may be more responsive to the question, we ought to understand the weight that comes with the words that the president speaks. So I hope that's responsive.
We got another one, and this maybe is a good segue for you too. Do the same rules apply to government actors in the form of social media?
There we go. Thank you for the nice segue, free speech and social media. So maybe we can come back to this question after I run through the slide, but I hope that what I have would answer it sort of automatically. So let's start with the idea that there's really two sets of questions relating to social media when we think about freedom of speech. One question is, can the government regulate social media? Or does regulation of social media and the social media providers violate free speech? This is dealing with circumstances where the government might say, Facebook, you can't allow false postings or false information about COVID-19 or the like. Or where the government targets the speaker. You posted stuff on Facebook, we're coming after you because that is unlawful. So in this circumstance, we're dealing with the highest levels of free speech protection. And any effort by the government to limit the content of speech on a social media platform, Twitter, Facebook, Snapchat, whatever, is going to be a problem and likely violate the First Amendment. On the other hand, there's certain kinds of speech that the government can probably proscribe, like threats, obscenity, and the like. When it comes to regulating the platform, the social media provider, a big question is whether the social media provider can be held responsible for the content of the speech. And this is something we were talking about earlier. So if somebody puts something illegal on Facebook, can Facebook be held accountable for that illegal information? And It really depends on whether we think of a provider like Facebook as a speaker in the same way that like a newspaper or a television station is a speaker that puts content out there and that controls the content, and then may have a point of view in terms of what content it pushes. Or is it merely a conduit for other people to speak, in which the platform performs no functions whatsoever other than to establish the medium through which other people speak? And I think that the legislation is designed to make social media more like the phone company, where it doesn't have to police what's on the platform because it's not responsible for what's on the platform. Now, that worked pretty well in the early days as a way of sort of making room for social media to grow and become popular. But I think we've also seen in recent years that there's a kind of monster that arises as a result of that. If people can say whatever they want on social media and there's nobody policing it. The result has been that social media companies are taking more and more aggressive action to police what's being said on their platforms. And as soon as they start doing that, they start acting more like speakers and less like the telephone company. At that point, they're going to invite more responsibility for the content of what's on the platform. So I think right now it's unclear where we're going to end up, but I think it's pretty clear that the current regime is not working very well, that there's not enough control of content. And I think what social media companies are doing is they're trying to rein in content in order to head off more aggressive government regulation. But at some level, the more aggressively they police what's on their platforms, the more they invite being regulated as if they were the speaker and being held responsible for what's on the platform. So I'm as unsure as anybody else as to where we're going to end up on all of this, but I'm watching with some interest. Now, current law sort of relieves them of responsibility. Now, a final sort of question is, well, what about regulation of content by the platform? So if I'm on Facebook and the platform removes my post, have they violated my free speech rights? And the answer to that really briefly is no, because they're a private company and the First Amendment and freedom of speech doesn't apply to private companies. And so they are free to post or allow to post whatever they want, take down whatever they want, and they haven't violated anybody's free speech rights. Now, this is an area that has produced a lot of interesting legal scholarship recently, because there are those who say, well, this rule that the First Amendment doesn't apply to social media is wrong. It should apply to social media, even though they're private companies. And the idea would be, well, you know, there's not much of a distinction anymore between that which is in the public sphere and that which is in the private sphere. And more importantly, social media is where speech takes place now. And if social media companies have absolute control over the speech that's on the platform, then people don't have freedom of speech, at least not in the context of the most common forms of communication that currently exist. So there are arguments for recognizing the social media as a kind of free speech forum that is exempt for or protected from content regulation, not only by government, but also by the platforms that provide it. So that is really what I have in my prepared remarks. I don't know whether I answered the social media question, maybe we can go there. If not, maybe we can just talk and people can ask questions and I can try to answer them.
I do have a question that came through.
Okay.
If the First Amendment is applied to the platforms, are they still considered a public forum, or do the platforms have to be considered as regulated?
Okay, so I'm not sure I fully understand the question. So the argument for free speech rights on the platform would be that the platforms are public forums. The argument against free speech on platforms, at least free speech from the platform's regulation, but I didn't say that very well. The argument against calling them public forums is that the platforms are private companies, and they, as private companies, can choose who they want to let on the platform and what they want to allow to be said. I don't know that there's much of a middle ground. Now, one thing the government might do is indirectly regulate or indirectly protect the content on platforms by regulating the platform provider, like Facebook or Twitter or the like. And the government, by regulating the platform, could either say you can't police the content on your platform, or they could say you must police the content on your platform. And the government would have at least some room to do either. But if it went too far, it would violate freedom of speech of the platform company. Ashley, do you think I answered that question?
If the person that asked it wants to unmute or send me a message, we can verify.
Yeah, that clarified it. I was just wondering because I remember listening to the hearing of Mark Zuckerberg, and he was trying to defend Facebook as a public forum. And the Republican senators like Ted Cruz were talking about how the regulation of content was allegedly biased. So I was wondering how private companies could still market themselves as public forums in the context of the First Amendment.
Okay, so yeah, I see what you're getting at. So first of all, Facebook or Twitter or the Wall Street Journal or MSNBC, they're free to be as biased as they want to be. And that's not going to violate the First Amendment. In contrast, the government's not free to be as biased as it wants to be in public forums. So as a legal reality, Facebook is not a public forum in the same way that a park would be a public forum for speech, because there's no constitutional protection against them policing. Now, I think so. When Zuckerberg says Facebook is a public forum, he's defending their choice not to police content by saying we're promoting First Amendment type values by letting people speak freely on our platform. And when Ted Cruz responds, he's saying, well, you're not really doing that. You're policing in ways that give you a direction. So that makes you not the protector of public forums, but rather a speaker in your own right, who's controlling the messages on your platform. And you don't get to claim that you're the mantle of free speech in that way.
Okay.
And I think Facebook is somewhere in between on those things.
Okay, thank you.
We do have another question. With Twitter becoming such a mainstream form of media, where should we draw the line between allowing them to promote what they want and interfering and possibly meddling with elections?
Oh, okay. So first of all, when it comes to elections, everyone gets to say whatever they want, as loud as they want, with as much money behind them as they want, and the free speech protects that right. So there is no line to be drawn on this point. Twitter can do what they want. They can endorse candidates. They can only allow tweets that favor their preferred candidates. And they have the right as a speaker to do that.
I don't have any other questions, but I suspect that there's probably some that are bubbling up in people's minds if anyone wants to ask or send me one.
So I want to come back to, as we're waiting, you all probably have heard of the Citizens United case, which is the decision where the Supreme Court basically said that corporations could use their money to make campaign advertisements without limit, which is part of what we saw in the most recent election cycle, where we just had a gazillion ads. Most of those ads are not paid for by the candidate. They're paid for by corporate money, often hidden, so we don't know exactly where it came from. And as long as they're made independently, they're not restricted at all.
I guess the question I'm trying to get at, that I tried to ask earlier, was like, because Twitter is such a powerful form of media and Trump like used it so much, if like during his re-election process, if Twitter had just banned him, would that not be considered election meddling because it's how he gets out to so many of his supporters?
Yeah, and because Twitter would be seen as a private company, and as a private company, it has a right to control its own speech. Twitter would have the ability to say no, and it would not be considered improper election meddling. That's just like Fox News can be as pro-Trump as it wants, and MSNBC can be as pro-Biden as it wants. Twitter could be as pro-Trump or pro-Biden as it wanted as well.
We do
Now,
have go ahead.
Yeah, just one final point. I think the more Twitter goes in that direction, the more likely it is to lose the protection it now has for the content of speech. So the limit is going to be Congress will start saying you're responsible and liable for the content of speech on your platform. The more you control it, the more you're responsible for it. The more anything goes, anybody says what they want, the less you're responsible for it.
Okay. Based on your reading of the tea leaves, do you see a basis for a successful challenge of Citizens United?
No, at least not until there's a significant change of direction on the Supreme Court. So Citizens United was decided pretty much on a straight party line vote, with the conservative justices recognizing the right of corporations to speak, and the liberal justices saying, no, you can regulate corporations and their use of money from their treasury. And since Citizens United, there are now more conservative justices on the court, not fewer. So as currently constituted, I think there are 6 justices who would strongly support Citizens United and only 3 that would oppose it. So it would either take court packing, expanding the size of the Supreme Court in order to appoint more liberal justices, or natural turnover on the court as conservative justices left the court for one reason or another, and liberals were appointed to replace them. I think that kind of outcome is probably why the nominations over the last few cycles have been so hotly contested. Not just Citizens United, but cases like Citizens United.
Any other questions? Also, feel free to unmute yourself. You can ask them out loud if you feel comfortable.
Professor, I just wanted to thank you for coming on and offering to do this. This has been great.
Thank you. Thank you. As a constitutional law professor, I can't tell you how often I see or hear people say things that are just wrong about the Constitution and what it means and what they think it means. And so I have always viewed an important part of my work and an important opportunity to educate people about the Constitution as it really operates and not just as they might imagine it.
Well, again, thank you for your time this evening and for the materials you presented.
I appreciate that. Thank you.
In your opinion, do you think, or do you feel like there should be more like government involvement in social media platforms like Twitter, or do you think it's good how it is now?
I personally think that there's not enough regulation of the content on social media, to be honest. Now, whether that should be done more by social media itself or more by government intervention, I'm a little less sure, although I tend to think, giving that power to Mark Zuckerberg versus giving that power to duly elected representatives, probably duly elected representatives would be the better recourse. But I think it would have to be done very, very carefully. And I would want it to be very, very limited. So the risk is always that, everybody wants to have their own speech and speech they agree with protected, and then they turn around and they want to shut down speech with which they don't agree. And so I guess if I were going to leave everybody with this sort of general principle to think about going forward, it would be whatever rules you support for restricting other people's speech, you ought to also support for restricting your own speech. And you ought to be thinking about rules that you don't mind if they're applied to you, rather than just, speech I don't like, I can restrict.